All right, the webinar should be started in just a minute, so just sit tight and we'll be right with you. All right, hello and welcome to the Micklin Law Group's monthly webinar series. Today's webinar is Protecting Your Assets, What Really Happens to Your Finances in a Divorce. This is a New Jersey Divorce and Family Court Attorney webinar. If you're watching at any time, this says current as of May 2025. Technically, today is June 13th, but not a lot has changed. The focus on today's webinar is going to be asset protection and divorce financial outcomes. My name is Brad Micklin. This is me. For those that have not worked with me, I'm an attorney in New Jersey. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. I will leave this here for 1 second. The QR code, I believe, allows you to get access to my meeting calendar if you want to quickly grab a spot. We will reach out to you beforehand for an intake just to make sure that there's no conflicts and that you qualify for our services. But this is an expedited way to get to us. I believe there's something similar on our website, micklinlawgroup.com also. Okay, so here is some clips I've done, and you can get the full interviews on my website, again, micklinlawgroup.com, as well as our YouTube page, Brad Michael Micklin. I have served as an international legal media consultant on various topics and various sources. Here we have Fox News, Inside Edition, Larry King Live, I-24 News, and various other ones. I don't put these here to impress people, but to impress upon you the experience that I have and that I hope to bring to the legal matters that we discuss. Here are some awards that I've been privileged to receive, both from client recognition and from peer groups. Again, not trying to dazzle people with pedigrees and awards, but just to confer the experience and the passion that I have for the work I do, that I hope shows through what I do and has hopefully in part led to some of these recognition and accolades. All right. Oops. Sorry about that. All right, let's jump into it. Understanding marital versus separate property in New Jersey. Probably one of the most complicated, but seemingly not so complicated issues in both divorce law as well as pre- and post-nuptials, which we will talk about briefly later in a future slide. Marital property, income earned during the marriage, real estate purchased together during the marriage, regardless of whose name's on the property, regardless of whose name is on the mortgage. Retirement accounts and investment accounts, again, regardless of title, and businesses started after the marriage, except possibly if they were started with premarital funds and there was no contribution from the wife, but that's a little intricate. The purpose of today's webinar is to give you kind of an overview. One thing I didn't say in the beginning is I will have, and already do have, many webinars on my YouTube page and my website that go more in depth on individual topics. Anything that you find too broadly covered here, you can certainly dive deeper into on those various sites. So versus what would be separate property, assets owned before the marriage, inheritances and gifts received during the marriage, if they are received by one spouse alone, or they're gifts from somebody other than the spouse, because spousal gifts are marital property. Assets that are acquired after the filing, if they are acquired in your own name and depending on pre- and post-nuptial agreements. Property designated as separate in agreements, again, post-nups and prenups, and as long as there is no commingling. So the reason I said that this is probably one of the more complicated areas, even though they're probably not often addressed, is there's really 4 different kinds of property that you will discuss in a divorce, but marital and separate are the most common that we talk about. But there's also active and passive. The simple definition: active is an asset that changes in value due to efforts and contribution, like a business or real estate that you pay a mortgage on or put a roof on, versus passive, which changes simply because of market conditions, like an investment account or a retirement account or the like. So you can have, for instance, a premarital active asset that raises in value because of marital contributions, and that becomes a post-marriage active asset that is not separate. Now, I don't expect you to really get all this. I'm just trying to explain that assets have more than one characteristic. So what might be considered separate property because you had it before your marriage may have a post-marital component that makes it a marital asset. Again, I do have a webinar specifically on active, passive, marital, and premarital assets if you're interested to dive a little deeper. But what I want you to take from this slide is that there's really 4 types of property. Sorry, my alarms keep going off. Living in the age of technology. Give me 1 second. Okay, moving on along. How New Jersey courts divide assets, the equitable distribution principle. First and most important, and I will say this a million times if we ever work together, equitable distribution is fair, not equal. The statute does not say equal. Now, many lawyers, many judges, many clients all think it's 50-50. It's not. It is equitable. There are there are many factors the court is supposed to consider, and one of them is any other factors, which is a broad sweeping category that can encompass anything that the court finds relevant. Things such as contribution, equal and unequal contribution, tax consequences, income that's generated, efforts that were put into it, pre and post-marital contributions, many, many things. Now, the starting point is going to be the assumption that marital assets get divided equally, and then to consider whether there is a reason to offset, which goes back to partly the slide that we just covered about marital and premarital. We will be dividing marital property equally to start, unless the statutory factors, which I won't go into in depth, but again, there's other webinars for that. If those factors lend to an unequal distribution, it should and shall be done so. So the court considerations, like I said, there are multiple factors determine fair distribution. I think there are about 14 of them, a few I mentioned just a second ago, but you can do a web browser search easy enough and just say New Jersey equitable distribution factors. And then lastly, financial analysis. Professional evaluations are often required. That's going to be possibly one of the more important factors, and to consider as early as you can. Not only will you need to get many of your assets evaluated or appraised, real estate, investment accounts, businesses, of course, but you may need to do that more than one time. First of all, there could be a premarital asset component. If you owned a piece of real estate before marriage and then you lived in it after you were married, that's going to have premarital and postmarital. You may need to get an evaluation that says what it was worth when you first got married and what it's worth today, for instance. And then sometimes you're going to need to update these evaluations because the divorce process may take some time. Some divorces can take a year, some 2, rarely, but can be possibly longer than that. And assets such as your real estate will change significantly in value. And marital homes are considered active assets. I'm trying to actually, I've had a split of opinion on that because some say it's passive, some say it's as active, depending on contributions during the marriage and whether you raised a family. But generally accepted is that it will be reevaluated at the time of the divorce if one of the parties is going to seek to reside in it. But the keynote to take from this is that, as I've said probably too often so far, is that it will not be equal distribution, and make sure to get evaluations before and during the divorce process. High net worth divorces, unique financial challenges. People think, those that don't have a high net worth divorce think, well, I wish I did, and how much it must be just so much better for them. That's not the case. High net divorces bring several complicated, costly, challenging issues, just like all divorces have. First, you have complex asset portfolios. You may have complicated business interests, multiple commercial real estate interests and properties, and diverse investments that create challenges when it comes to getting the evaluations that I mentioned a moment ago. Second, detailed documentation is necessary and sometimes difficult to obtain. There will often be extensive financial records that are essential for accurate asset accounting. Those that have been through a divorce and own a business know that getting that business evaluated is a challenging, complex, costly, and time-consuming endeavor, especially if you're the one who's running the business. You have your day-to-day efforts focused on your business, maintaining the business, generating the revenue that you need to keep going, as well as that which you may need to buy it. And here you're spending countless hours producing documents to get it evaluated. Which brings us to the expert assistance. Often we employ forensic accountants and financial analysts and team members to help with this evaluation. You are encouraged to have joint experts in the beginning. That means one expert that you both select to do the evaluations. You generally reserve the right to get either a rebuttal or your own independent if you're not pleased with that. Joint experts report, but it's a very good starting point with the hopes of expediting your litigation and minimizing your costs. Legal tools for asset protections. As I kept mentioning earlier, prenuptial and postnuptial agreements. A lot to unpack here. Prenuptial agreement, many people are familiar with, establishes asset divisions and rules such as alimony limitations before marriage. Inside of your prenup, you will often have asset classification. That's very important, which designates what is and is not separate marital property. The mere definition is not so simple because you may want to consider something that you have premarital in your marital assets. You may want to designate how something that is premarital, if it's utilized in the marriage, whether it keeps the separate distinction or not. Next, postnuptial agreements, as the name suggests, are done after the marriage. They're often, not often, they are sometimes called reconciliation agreements or mid-marriage agreements. Those that are going to do research want to look at those terms. Creates protection after the marriage has begun, but before a divorce. And legal enforcement regarding both of these requires all of these types of agreements to be properly executed, free from coercion, with complete asset disclosures on both sides. So a couple things about prenups. First of all, the prenuptial agreement laws have changed in New Jersey. I was going to say over time, but that's obvious. So some agreements, if they were written before the prenuptial laws were changed, are going to be enforced and viewed differently, and as opposed to those after. The basic change in the law was prenuptial agreements used to be viewed at the time of the divorce as to whether or not they were fair. They are now viewed at the time they were entered to determine whether or not they were fair. And that's a huge distinction. Most of us view or consider prenups to be always challenged and always fail, because that's just generally what we hear. And that's because, and it's not true necessarily, but it is in part true because the way the law used to be written, which said we view the fairness of a prenup at the time of the divorce led most to be viewed as unfair. And the reason is you would enter an agreement on a certain day when you're young and you're starting out and you may not have much, if anything, in the way of assets. And then many, many years or decades later, you have substantial assets and advanced degrees and children and spouses that haven't worked. And the agreements were almost always considered unfair because at this time now people were unemployed for many decades and unemployable, and assets that were utilized for a certain lifestyle are now going to be considered separate and out of reach of that. So often they would fail. Well, they changed that because it basically wasn't fair to make the law read that way because it was too easy for an agreement to fail. And those who entered prenuptial agreements relied on them through their marriage and made decisions based on that, only to find that in a divorce, courts were knocking them down and giving alimony and distribution of assets. It wasn't fair. You make an agreement and you live by your agreement, good or bad. So they changed it. And now it's got to be, if the agreement is fair at the time of execution, it will be upheld at the time of the divorce. Now, what that means simply, and again, I know I sound like a broken record, so go to my other YouTube videos and my websites for more in depth, but it means that it had to be at what's called arm's length, which means you each had fair chance to negotiate the terms. The attorney is not required, but it's certainly encouraged. You must have full disclosure of your assets and debts. Now, there's some debate as to whether or not you need to attach actual physical statements, tax returns, valuations, account statements, or whether or not you just need to have a typed up attachment itemizing the assets and debts. I say when in doubt, put in everything you can, because again, you want to make sure that this upholds and you want to make sure it was fair. I mean, the basic litmus test is, it was fair. So if there was something that was missing, it might be considered unfair. So if you have to put it in the kitchen sink. Postnuptial agreements are a different animal entirely, not just because they're done after you're married, but because the law disfavors them. The general opinion of New Jersey jurisprudence is that a postnuptial agreement is wrought with coercion, meaning sign this or I'm leaving you. So people sign it, regardless of whether it's fair. They're signing it in the eyes of the law at a time where there's maybe a great deal of acrimony and distrust and emotions, as opposed to a prenup, when is you generally care most about one another, and that's right before your marriage. So the law currently does not favor a postnuptial. That does not mean you can't have one and that they're not enforceable. It just means you have to be much more careful in your execution and in your disclosures, so that the fairness criteria that we talked about a minute ago with prenup is met when you draft your postnup. Asset protection strategies before and during your divorce. Financial transparency. Full disclosure is legally required. Hiding assets leads to penalties and lost credibility. Trust establishments, you can create certain trusts through estate planning that, when properly structured, can protect specific assets from division, as well as preserve them for your children and future. And using documentary practice to keep meticulous records of your separate property from before and during your divorce, as well as in your process, will help you maintain clear financial boundaries. The most important part about financial transparency to know is, not only are you required to disclose, obviously, all of your assets, but failure to do so is considered fraud. And if it's discovered that you committed fraud in your failing to disclose assets, your entire divorce settlement or your entire divorce judgment can be vacated, reopened, and started again. To those that have been through a divorce, you'll know that is the last thing anybody who's been in the process wants, is to start it over again. And if you concealed assets or you failed to disclose assets, that is the course that will happen. Now, there's a counter argument to that, and it is the other party had chance to do discovery. In many cases where there's settlement, which is the majority of cases, people discard the financial disclosures. They abandon them before they're completed. And in some cases, the non-disclosure is deemed to be waived because it wasn't that it was being withheld, it just hadn't been disclosed. Let's say, for instance, there was an asset that was sold and money put into an account. If the account is disclosed, but the prior transfer wasn't, or the tax consequence for the payment, that might not be unlawful. The key to remember is if you had the right to exchange the information, to obtain the information, to investigate a claim for an asset, and you did not, you might have waived it. It might not be an issue of non-disclosure. It might be an issue of your waiver and abandonment. So key point is make sure that you either complete and obtain all of the financial information about all of your assets and debts, or understand that you may be abandoning those that you have not, and be ready to live with that. Common financial pitfalls and how to avoid them. First, asset concealment. Courts penalize hiding assets. Just said that. I don't want to beat a point to death, but it's very easy to accidentally forget about an account. You have an old 401k from a prior employer that you don't disclose because you don't remember it. You had bonds that were given to you as a gift. Maybe you have those old EE bonds in a safe deposit box that you've been holding on to for decades upon decades, and you don't remember you had them. Cryptocurrency, big issue now because it's hard to trace. They're hard to value. Gold, if you have it in the physical form, you could have it in a safe deposit box or jewelry. I mean, there's a lot of things that could be considered concealment. Very important that you itemize and list everything that you have. Second, pitfall, poor documentation, inadequate records which jeopardize claims. Not just in evaluations like we talked about, but in getting tax returns, in getting payoff statements, and getting the appraisals that we talked about. It is very cumbersome in a divorce to have to get a lot of financial information. People are generally not in the practice of keeping up, extensive records, even business owners, especially with the increase in invention of electronic storage and communication and transmission. Many of us have gotten even less inclined to save documents because you can go to your bank and just hit download and get all of your bank statements. But it's important that you take the time throughout your divorce process to obtain and provide and exchange all of your information. And lastly, tax blindness, overlooking tax consequences. And I may touch on this in another slide, but it's very important that you speak to a tax accountant, even if you understand tax consequences and the tax code itself, to understand the consequences of the tax implications of the assets that you're taking. Because when you take an asset in divorce, quite simply, there's usually no immediate tax consequence to it. But later, when you utilize or you sell or you liquidate or you transfer that asset, there may be significant tax consequences. So I'm on what I believe is the last summary and key takeaways and best practices. I'm just trying to see if there's more I wanted to talk about when it comes to understanding your tax consequences. And again, it's just something I want to stress because every asset will have a different tax consequence, not just in the trigger when you sell it, but because of the basis. So a lot of times in divorces, for instance, people treat assets almost as if they're equal. If a house is worth $100,000 and a retirement account is worth $100,000, one will keep the house, one will keep the retirement account. Without realizing first, obviously, when you take out your retirement account, if you take it out now, for instance, prior to retirement age, there's going to be tax consequence and penalties. Whereas if you sell your house, there's usually none. But even that's not necessarily entirely accurate because depending on how much profit you got on your house, you may be taxed on the profit. And the profit for a house, if you're going to sell during your divorce, you should look to sell it before your divorce because the appreciation taxation may be more impactful if you're divorced and filing separate returns when you sell the marital residence. I'm not going to go into in-depth explanation about that, and I'm sorry if it sounds a little convoluted, but that's why I say talk to an accountant. You basically need to know for any asset that you're transferring, you want to know what it was originally purchased for, which is called the basis. You want to know what it's valued at now. You want to know what the tax consequence will be to you when you sell it, and what is the tax rate at which that you will pay. Because those three factors are very different. They will change possibly over time and have a very significant difference in the future that you might not be contemplating. So, taking the house now and giving up the retirement account may not have the same net effect that you think. So, coming lastly to our summary key takeaways and best practices. One, and I've said this, I know many times, it's a pet peeve of mine, but equitable distribution, courts focus on fairness, not equality. Very important to remember, very important to continue to impress upon your attorney and your judge and your adversary that it's not supposed to be equal. Two, expert guidance. Work with specialized attorneys and financial advisors. I don't say that because I am an attorney. When I got divorced, I hired an attorney. When I have a tax issue, I go to an accountant. Not just because you want expertise, but you want objectivity and independence. You yourself are not likely to be objective and impartial, even if you know the tax code, even if you know the law. It's still good to have somebody independent who is going to advise you about these. Proactive protection. Prenuptial agreements, trust planning, postnuptial agreements all provide forward-looking security before, during, and after your marriage. All of them, as I've mentioned, have different levels of disclosure, different impacts, but ultimately all the same purpose: to eliminate litigation and to facilitate resolution. Documentation necessary at all stages, from your prenup through to your postnup, all the way to your divorce. You must have and maintain meticulous records of your separate assets, when you acquired them, what they're worth now, and anything that happened in the meantime that needs to be accounted. If you want to contact me, here's my brief contact information, the Micklin Law Group. Our phone number, 973-562-0100. My website, which appears here, is Micklin Law Group. That's MICKLINLAWGROUP.com. And my YouTube page, which I usually recommend a little more than my website because it's got more information and it's a little easier to search, is my YouTube page, which is Brad Michael Micklin, MICKLIN, once again. Give you a second to take all that information down. We obviously, like everybody else, we have social media. So in addition to the YouTube, which I put a link here, but I don't know if you can actually copy and paste it. But we are also on Facebook, Micklin Law Group, and LinkedIn, Micklin Law Group, once again. I do not believe that we are on, I guess it's called X now. It used to be known as Twitter, but you can tell, obviously, I don't even know exactly what it's called, so as I don't participate in it. But you can also contact us through those various channels. One thing to remember, if you contact us that way, we may or may not respond. I try my best to respond to comments and questions about my videos and my posts, but it's important to remember that not only through those channels as well as this video, that it is not considered legal advice. We are not creating an attorney-client relationship. This and all the information like it is considered attorney advertising. We're putting it up just to help you along. And lastly, I put this last so I don't have to take time to say it and you don't have to take time to read it, but you can and should. This is our disclaimer, which is basically a longer version of what I just told you about this being advertising and not creating the attorney-client relationship. I will give you a moment to read all this to make sure that you're well versed in these long and very important legal disclaimers. And with that, I will thank you for logging in and taking this time to go through this material. I hope that it helps you or somebody that you care about. As I've said a dozen times, I do have a great deal of other information that's available on my other social media platforms that I hope will help you and certainly are available to you. I put them up because I found over the decades of practice that people don't even know what to ask at the beginning of a process or in an initial consultation. So I try to create resources that give you the information that you're wondering about or you're questioning. And then from there, you can take those questions that result or remain after that and then find more specific information, hopefully through my office or any other professional that you think will help you. With that, again, thank you for spending this time with us, and I wish you all good luck. Be safe.